this month, I'm going to talk about a Court of Appeals case which is recommended for publication, which is sort of unusual enough as it is. We've been averaging about 2 or 3 Court of Appeals cases per year recommended for publication. So it's nice to get one we can talk about rather than one of the unpublished cases. And in Flu this month, we talk about a case called Glidewell versus Glidewell. And it's a case involving the issue of joint legal custody and domestic violence. And actually, of the 2 areas of the decision, the domestic violence one is probably the lesser interesting one. What it holds essentially is that you can't agree to joint legal custody and then later on contest it because there's a domestic violence issue that arose prior to you stipulating the joint legal custody. It's a waiver issue, and what the trial court decided, affirmed by the Court of Appeals, is that the mother in the case waived the objection to joint legal custody based upon domestic violence when she didn't raise the issue initially. And that seems to make a lot of sense. It's not a new issue, domestic violence, that arose later. It's one previously. And if the issue is going to be raised and the presumption against joint legal custody, where there are areas of domestic violence, have to be raised initially, not later. It's the second part of the case that I want to talk about for a minute, which deals with whether or not the trial court abused or misused, on the current terminology, its discretion in agreeing to joint legal custody under the circumstances of this case. In Wisconsin, there's legally a strong presumption of joint legal custody, and practically speaking, a very strong presumption. It just seems like every case, unless somebody's not interested in it, somebody's disappeared from the children's lives, or they're a convicted sexual predator of some sense, that every case seems to be joint legal custody. And the argument that arises a lot is, well, we don't get along. Well, yeah, no kidding. People did get along, they wouldn't be going through a divorce. So it's sort of, where's the line drawn where we can't get along to the point where joint legal custody is no longer in the best interests of the children. What it seems the court did in Glidewell is to award decision-making to the parents individually on certain issues. And our statutes allow the trial courts to do that. So it can say, well, it's going to be joint legal custody, but if you can't agree on, say, schooling, then mother or father is going to be the tiebreaker and can make the decision. The end of the game in this is that joint legal custody is stripped of any real meaning. It doesn't mean the 2 parties have to sit down and talk or go to mediation or whatever. It becomes a title only, because if one of the parties has tie-breaking authority, then that sort of will end the discussion, because that party can trump whatever the other party wants to do. And I don't think that's the worst scenario at all. Even though the end effect of it is that joint legal custody becomes more symbolic than practical, symbols are important, and it is meaningful. And to tell a parent, hey, you have no custodial rights at all, is a means of discouraging that parent from active involvement in the children's lives. One of the things we know from studies is that children tend to do better with 2 active parents involved in their lives. So if the active involvement of parents is more of a legal fiction or more symbolic than practical, it's still better than the alternative of having a parent who has no incentive to be involved in the children's lives at all. Best for children, of course, is to have 2 good active parents who can cooperate with each other, but if people could do that, odds are they'd probably stay married to each other. So as typical in this field, if you can't have the ultimate best, we move to the next. And I think the trial court in Glidewell did it correctly, and as loath as I am to compliment the Court of Appeals on anything, it's more fun to criticize them, but I think they were right in sustaining the Court of Appeals in this instance.